So we decided to get our experts in to answer your queries. Joining me in studio, I have Darren, Olivier, Llewellyn, Parker and Frank Joffe. Welcome back, gentlemen, to Eureka. So we're doing something different today because we just found all these emails coming in and people have a lot of queries in terms of the legal aspect. So let's get to it. We start off with Itan Mushawela, who's asking, what is the first thing I should do in regards to protecting my intellectual property? Llewellyn, would you like to take that one on?
Well, I think probably the first thing that should be done is to take out that much needed second mortgage on your house. No, to be serious about it. I think what the first thing to do is to establish whether you have the right and then the best way to protect it. And the best way of doing that is literally consult with an attorney, preferably an intellectual property attorney. If not, then your ordinary general attorney should also be able to refer you to an intellectual property attorney. And then you can take out that mortgage.
Anything to add?
Yes, all I'd say is that intellectual property attorneys generally, and patent attorneys in particular, take about 10 years to qualify. They have to have engineering or science degrees, they have to have law degrees, and then they have to pass professional exams. If you're the kind of person who would consider taking out your friend's appendix, and then by all means go ahead and try and protect your intellectual property on your own. But otherwise you're well advised to consult an intellectual property lawyer.
There was actually a question from one of our viewers, Vusimbele, that said, I have an interest in practicing as an IP attorney. What qualifications do I need? Would you like to, Frank, maybe just continue on that?
Well, there are generally two types of intellectual property attorneys. Darren can talk about trademark attorneys, but as far as patent attorneys are concerned, you must have a technical qualification, which is generally an engineering degree or a science degree. You must have a legal qualification, you must be admitted as an attorney, and then there are certain professional examinations that you have to pass as well.
Hence it takes 10 years.
Hence about 10 years.
Darren?
Sure. I didn't have to wait that long, just as well. You can have a general commercial degree or an LLB or be an attorney in this country. In some countries you don't even have to be an attorney. The idea on brands and trademarks is an ability to communicate with marketing departments. Certainly you have to understand the law, and certainly if you get into litigation you have to be a solicitor or an attorney. But the qualifications are not quite as you don't have to have a technical background. I think one thing that people make a mistake on is that they think in order to be an IP attorney you have to have a technical background, and so it's quite comforting to know that you don't necessarily.
It depends on where you're going to specialize.
It depends on what you're going to do. Yeah.
Okay, let's look at this, the third question from Thomas Reed. I have a great product. I've seen a great product in the USA. Can I patent it in South Africa, Frank?
Well, the answer is no. Generally, in order for an invention to be patentable, it must be new. And in patent terms, an invention is new if it has not been disclosed to the public anywhere in the world in any manner by any person prior to the date on which you file the patent application. So the answer is you can't, if you've seen the product in the United States, you can't patent it in South Africa.
But chances being that it would be patented on a global scale would be quite good, depending on the product.
It depends entirely on the product, and quite often that's not the case. In many cases, products are patented in some countries and not in others. So the fact that you can't patent it in South Africa doesn't necessarily mean you can't manufacture it in South Africa. It just means that you can't have monopoly rights. You could get a license. You can apply for a license if it is patented.
Right.
And related to that, there's another issue, which is a question that's often asked to us, and that is we get a client coming to us saying, I've got this marvelous product. I've developed it to the stage where it's ready for the market, and I actually showed it at a trade show. And the response was enormous. People loved it. I now want to patent the invention so that I can protect it and go to market. And that is a tragic inquiry that we quite often get, because the answer, just as with the question about the United States, the answer is it's too late. You can't patent the invention any longer. It's been disclosed to the public.
I'll just say something, going back to that, the first part of that. the rights in intellectual property vest in its creator. So if you saw this thing, you're not the creator, you're not entitled to get rights. The second aspect is not that difficult, and is not that simple, and that is, if it has been exhibited at a trade show. I'm not so sure that I agree with you, Frank, simply because the United States, for example, has a provision in terms of which you can file up to 12 months after disclosing it. So yes, I think that's the only country that has such a provision. You may still be able to file that thing in the United States. South Africa, no, forget it. And then it just depends on what you're looking for.
Why the difference between countries, though?
Because they're national laws. The United States is, for example, in the United States you can get a patent for a scheme or method of doing business. Cannot in South Africa. Program for a computer. Cannot in South Africa. In fact, you cannot in pretty much the rest of the world. So it's just national laws. We've all tried to harmonize as best we can, but there are still, and some of the differences are quite significant.
Let's look at the next question. I think this one's for you, Darren. Colleen de Vet wants to know, I registered the company name and the domain name, but now I'm being sued for trademark infringement.
A common mistake, actually. People go out and they'll go to Cipro and do all the diligent searches on the company names register. They'll go and get the domain name, and they think they have rights to the trademark. And unfortunately, when they register the company names, they don't check the trademark register.
Two different things, right?
Two completely different things. But I think the most powerful thing is the trademark register, because that is the only register that's going to give you rights to infringe, and also to check if you can, in fact, use that mark. And
so you're saying start with the trademark?
Yeah, check the trademark register, see if you can use it anywhere at all. And it's actually a large part of our business is that exact query.
Next one, Tabo Musi. Can I overprotect my intellectual property? Who would like to take this one?
I think you can.
Yes, you can. Intellectual property is territorial in its effect. So in other words, if I want protection for an invention, a paper, by way of a patent, I must file an application in each country in which I want protection. Now let's assume that my form of protection is, or what I have, is some rather fancy means for prospecting for oil. I would be wasting my time applying for protection in South Africa because I don't have any oil.
Right.
That's the one aspect. The other aspect is to see exactly what it is that you're hoping to get. And again, if I can give an example, let's assume we have a known product, aspirin, and there's nothing fancy about that. It's off patent, anyone can make it. I come up with a new process for producing that aspirin, which is patentable. It's new, it's inventive, and it qualifies. What am I going to do with this patent? Who am I going to sue? Remember, your major manufacturers of pharmaceuticals are not in South Africa. So it's now going to now go outside. How on earth am I going to find out that they are actually infringing this thing? Furthermore, in that patent specification, I must disclose the best method, the best way of performing my method. So I'm giving away all my secrets. Sometimes you can protect it simply by keeping it secret. And I think that goes back to what Frank said right at the beginning. What do you do if you've got this intellectual property? You consult, preferably, an intellectual property lawyer who can sit down and say, what do you want to do? What have you got? And you may find that you can protect it more effectively by keeping it secret, in which case the costs are reduced from this second mortgage I was talking about to almost nothing.
But are you finding that a lot of people are going into it blindly? You know, do you find a lot of calls come through where guys have gone, down that road and then come, to seek expert advice? What is the general feeling? Okay.
I spend the greater part of my life trying to get a lot of people out of situations they shouldn't have gotten into in the first place.
That's an educational process, isn't it?
Part educational, and I think also that one must realize that yes, there's a danger of overprotecting, but the value in protecting, especially on the trademark side of things, the cost of protecting a trademark is super small in comparison to the cost of a lawsuit.
Right.
And I think that the idea is to spend your money on the protection side, spend your budget on the protection side rather than facing an infringement action, either defending infringement action or enforcing it in court. It's much easier with a registered trademark.
I think we're time for one or two more. Frank, I think this one's for you. I want to patent my invention, but how do I do that without knowing that someone at the patent office is not stealing it?
Yeah, this is the kind of question that we sometimes get from people, and they even go further and they say, how do I know that if I tell you about my invention you won't steal it?
You're not going to steal it, yeah,
Yes.
right.
And there's no easy answer to that. The fact of the matter is that the contents of a patent document are secret. They are handed to the patent office, and the patent office simply stamps them and says that it's received them. And once you've got the stamped application form back, you've got a date on which you filed your patent application. At that stage, it doesn't really matter if somebody discloses what's in the document because you've already filed it. I mean, to some extent, it doesn't matter. They receive thousands of patent applications a year. They're not qualified to decide which ones are likely to be valuable and not. And having said that, I've never in all of my career heard of a situation where something like that has been alleged or proved, that someone at the patent office has stolen an invention. And by the same token, patent attorneys are professionals in the law profession. They have certain professional obligations. They are subject to privilege, as any lawyer is, and it's inconceivable that an attorney, a patent attorney, would run off with someone's invention. But I can't offer any...
It's a fair question.
Yeah,
it's a fair question if you don't know. We've got time for one more. So closing question to Darren. I want to protect my new internet site. Please protect my IP worldwide.
This is one's quite common. Your internet site is obviously available across the world, and I think it just gets us back to the idea that trademarks are, in fact, IP is territorial. It's just not cost effective to protect your trademark across 120 different countries. There are various ways in which you can cover a number of countries with one single application. But the best advice to that type of person with that type of query is to assess where you're intending to market your goods. That's the primary market. And then there might be also defensive markets. If you've got competitors in a space, maybe in surrounding countries, you also might want to protect there as well.
We're going to have to leave it there, gentlemen. Thank you so much and for your contribution throughout the season.